precedent. All right, now let's keep going.
I don't like case law, but
nobody
that's what we
officially
have.
passed the,
Agreed.
Noit Roba, what is it? Yeah, Noit Roba law. But after Roe v. Wade, then guess what? That made Roit Nova legal. That's what that was. That's case law. Nobody passed it, but they found for the plaintiff in court. So that's case law.
So basically, could you imagine a world where, because you don't like how you came across on a TV broadcast or radio broadcast or something like that, you could sue for hurt feelings?
Right.
We would have no broadcasts.
Right. We'd all be.
Well, let me say this. In America, anybody can sue. You know what I mean? That don't mean you're going to win. Of course, your case have to have a proper cause of action. You got to have merit to what you're saying. You got to be able to prove the injury that happened. See, in order to have a legitimate lawsuit, they have something called case and controversy. You know what I'm saying? So you have to have an injury. It has to be some type of injury that exists, and you have to use the proper cause of action to prove that you were injured. So yeah, I mean, anybody can file a lawsuit. It don't mean you're going to win it though.
Right. I want to add something too, because he said that you think that people can sue if they go on a talk show or a TV show and their feelings get hurt. But what he's not talking about is before you go on a TV show, where your image, as far as your picture is reused, you're waiving that right. You know what I'm saying? And then I'm not gonna get ahead of the video because I saw the video prior.
Right.
But it's something else that he's gonna bring up that I want to talk about as well. But what he's saying, he's a little misguided in what he's saying, although what he's saying is true.
Right.
But what he's saying, the part that's true in his case is don't have to particularly, it doesn't specifically have to be about his case, but he believes that it is. You know what I'm saying? Because that statement that he made was that when you go on a TV show, you can't sue for getting embarrassed, but he's not discussing the underlying before you go and show your image and your image is used. You know what I'm saying? There's waivers, there's signed, there's compensation provided in order to use someone's likeness that he's not talking about. But go ahead.
I agree. All right, let's keep going.
Be broke, dude.
No. There would not be. Okay. How many people have gone onto a TV show or a radio show and have not had the best showing?
Happens all the time.
So in other words, but see what people try to get, well, you have to sign a media release. That's for a different set of circumstances. Social media is not governed the same way as stuff by the Article 230.
All right, let me stop right there, because what he's saying right there, that social media, right, which is YouTube, is governed differently than, let's say, like a commercial or advertisement or somebody going on television, right? Now, I have to say that I actually disagree with him concerning that. Now, I'm gonna go back to this case law. All right. And
I disagree with it too, and I also glad you stopped it right on the 230. That's what I didn't want to go ahead of.
Oh, gotcha.
And the Article 230, that's what I want to slightly address, but not too much. Go ahead.
Right. All right. What I want to point out is this part of this particular case. It says our Supreme Court has held that a right of privacy exists in North Carolina and has recognized the first type of privacy tort being invasion of privacy by the unauthorized appropriation of a plaintiff's photographic likeness for a defendant's advantage as part of an advertisement or commercial enterprise. Now, the reason I had to point this out is because there is a possibility that the courts in North Carolina will, right, determine that social media or of the likes of YouTube, right, where people actually, or content creators, are paid by views. So the amount of views they get, they actually receive revenue for that, right? There is a possibility that the courts in North Carolina would view that as a form of commercial enterprise. All right. So I wanted to make that very clear.
And let me just go into the case law again, like what you have highlighted.
Yes.
This little phrase can become law. This for people who, this to show people how to use case law. So if I was working for Miss Jessica, I would use this case law right here, 1996, which is prior to, I think the end. Was that prior to social media, 1996?
Yes, I believe YouTube came
okay,
out. Well, I believe YouTube came out around that time, but yeah, for the most part.
Yes. So therefore, they will have to. This could become a novel case, but this case right here will set precedent to sway it in her favor. That statement right there.
Yep.
Because it's unauthorized appropriation of plaintiff photographic likeness for a defendant's advantage as part of an advertisement or commercial enterprise. See, that commercial enterprise is YouTube. You know what I'm saying?
Hey, Roddy, let me tell you, I may cut you off, but so many times, again, I'm making it clear. I'm a fan. You know, I want Kevin to succeed on the merits, but I can see how Jessica could win this because YouTube can't be considered a commercial enterprise. It can.
Yeah,
you know, and it's case law to support that it was a possible violation of her privacy. That's why we're pointing this out, because see, I want people to understand, like, again, Kevin and Donovan Sharp are intelligent brothers, and they are somewhat knowledgeable in what they're talking about in this video. However, there is case law that exists that supports a claim for privacy, for a violation of privacy, which will be her cause of action. You know what I'm saying?
Yeah. The case law can really smash them. You know what I'm saying? That's pretty much so it'll be like, if the case is brought properly by Miss Jessica and the other young lady, Kevin's defense would be it won't be successful. Right. You know, he'd be pretty much, it'd almost be like if you're selling narcotics and you're selling drugs, right? And the and the alphabet soup, the FBI, DEA, all that, they kind of know what you're doing. So what they do, they start watching. So they watch you to a point to where that the feds ever come, and then you get a feeling somebody tip you on the inside, right? Maybe a couple months down the line, yeah, I think they watch you, be careful, and you just stop all business. You stop everything what they consider to be illegal, and you doing nothing for the next 2 or 3 months, but they still watching. So if they come get you off the streets, pick you up off the streets, it's gonna be hard to beat that case because they got a lot of law against you. You know what I'm saying? That's what. So in other words, you're gonna be wasting money. If they come get you, you waste the money by giving money to a defense attorney. You need to save that money for your commissary because you're going to the penalty box. If Miss Jessica bring her case properly, all the money that Kevin is defending on defense, he might as well save that money for his commissary or for his next business venture. You know what I'm saying? That's what I'm saying. It's equivalent to, it's the same. When the feds come get you off the streets, it's a slam dunk because they got so much on you, plus they're gonna lie, that you might as well save your little chump change for your attorney who's gonna sell you out down the road after you just go through that 6 or 7 months of playing with the law to get to actually take your money, save that money for commissary. So in other words, if there's just, that's why we want to see the lawsuit. If we see that lawsuit, I can determine, I'm sure you can too, Keith, whether or not a defense or he should settle. They call it in the civil terms, you settle the case. Right. And that's what the position that he would be in if she bring that case properly.
I agree.
And that case law that you just highlighted, that's all she needs.
Yeah.
Everything else is irrelevant. Trust me. But if her case is not properly and she bring her case in there with another thing that he was saying, because Kevin knows the case because the case was brought against him. He also spoke on about her feelings being hurt. So if Miss Jessica lawsuit is couched in a manner where it suggests that her feelings is hurt, her privacy was invaded, and it's not talking about her image and likeness, but I believe it is based on what the other sister was speaking about in the first video. Kevin gonna have some issues with that unless he has a waiver. But he's saying that he doesn't have a waiver because he said earlier in this video right here that when you have to sign something And so he feels that you don't have to sign anything because he feels as though YouTube is not part of
right.
being
He's
able
saying
to waive your rights.
he's saying
So
social media.
So he's
is
misguided
different.
in a lot of legal aspects. Go ahead.
Right. He's saying social media is different than television. In other words, that's what he's saying. And I know he brought up Section 230. Section 230 does have civil liability claims, but what they're discussing, the whole issue right here, does not fall within the scope of that law. So to me, bringing up Section 230 is a waste of time, essentially.
Let me explain quickly why 230 has nothing to do with what this claim should be about. Because 230 is talking about like a radio show, like your voice. It's not talking about your image. Those are two separate things. It's your voice and it's your photographic likeness, aka image.
Well, let me say this though, Rodney. Section 230 does deal with social media. It does.
But
However,
it's not talking about
no,
but it's talking about everything that I've seen in that, because I read 230. It's talking about your voice likeness. It's not speaking of your bring that joint out right quick. It's not talking about what I've seen. I didn't see it speak about your image. It's speaking about bring that joint. Not that. It's a section.
Yeah. It's I'm about to scroll down to it because it deals with like internet and interactive computer services, which is social media. But right here, it has a section for civil liability. And what they're discussing, or what the issue is between Jessica and Kevin Samuels, has nothing to do with the civil liability section within this law.
That's talking about it, like sexual stuff, like crazy, the stuff that had nothing to do with them.
Yeah, violence,
but I found the
stuff
section.
like that. Mm-hmm.
I think I found a section because isn't this a U.S. code?
Yeah, it's I think it's
found
Title
something
47.
in the statute of laws that talked about or maybe it wasn't this one that was talking about the voice. It didn't bring the image. The only image that they talk about is like lewd and sexual images. It's not talking about just your everyday organic image. If you talk about your everyday organic image, this doesn't protect it.
Right.
If you're talking about an image capture, you know what I'm saying? If your image was captured and a sexual image was captured, then that's what this law is talking about.
Right.
Is that what you're talking about?
Well, yeah, it deals with that. It deals with fighting words, violent words. It deals with all of that. It basically it makes it where the platform provider like YouTube wouldn't be responsible for civil liability if those things was posted by one of their users like that. That's why I'm like, Section 230 has nothing to do with this whole dispute.
That's a protection for YouTube, not a protection for the but does it say it's users as well? I thought
it's for users as well.
Okay,
but we've been dealing with violation of privacy. These ladies have specifically been saying violation of privacy. You know what I'm saying? And I know that First Lady did say image and likeness, so she actually did use keywords.
Exactly. Those are key words right there. There you go. And she could combine those causes of actions to try to make more stick.
Right.
Which was the image and likeness, the invasion of privacy, the hurt my feelings. So you can bring up all those causes of action, and Kevin, just like his attorney, is doing the right thing, just attacking what they can overcome. Hey, I can overcome her feelings being hurt. Hey, I can overcome her what's the other claim? The feelings hurt, and what's the other claim? Invasion of privacy.
Invasion of privacy. Yeah.
He can overcome those claims, so that's what his attorney probably would attack if those claims were added to her lawsuit. Right. But if that image claim is dangling out here over here, if it's dangling over here, they're gonna have to deal with it sooner or later. They may not deal with it in their response, but they're gonna have to deal with it after their response.
I agree.